Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. Every immigration firm has one. You know, the person who remembers every deadline, who keeps clients from spiraling, who knows exactly where the missing document is. I'm talking about the person everyone turns to when things get complicated. Usually, it's a paralegal. And usually they don't get nearly enough recognition for the work that they do. The podcast friends at e-Immigration are trying to change that with the Heroes Spotlight, a campaign celebrating the top immigration paralegals providing the backbone of immigration law. If someone in your practice deserves that spotlight, nominate them before September 25th. Go to heroes.eimmigration.com and give credit where credit is due, or click on the special link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and is intended to keep you up to date and enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. The circuit's finally let up a bit, everybody. Praise. The U.S. government has not with immigration, what with new public charge rules waking up from the dead with a vengeance, deportation flights to Haiti of former TPS holders, and what appears to be the beginning of a serious narrowing of WebEx appearance allowance in immigration court. Fight on, we do. Also this week, in a sentence I could never have imagined I would have said 2 years ago, the Fourth Circuit upheld a lower court order preliminarily barring the U.S. government from storming places of worship in search of immigrants. An image reminiscent of the 1930s, and certainly The Sound of Music, right? Which I have previously mentioned I finally got around to seeing, so it is admittingly a bit top of mind. Finally, I have something special for you all before we get to the cases. As nearly none of you know, I edited this podcast myself every single week for like the first 5 years of its existence. Those of you who have ever edited audio know it took hours and hours of time every weekend. Made me a much better public speaker though. Nothing like editing yourself 250 times in a row to make you get rid of filler words and ums. The only reason I could keep this podcast up was because I finally found editors. After using some wonderful law students for a little bit, I came upon the company Pod Populi, which does a lot of things podcast, including running brick and mortar buildings throughout the United States where you or your kids can go and record a podcast of your own. I use them simply for editing my podcast every week, and they have been a lifesaver for me, you, and me, you. Link to Pod Populi in the show notes. For the majority of my time with Pod Populi, my editor has been Miles Mendez. Miles is not an attorney, and I believe knew very little about law or immigration before hopping on this journey. Now, he's edited hundreds of decisions, and I know he's listening. I know it. He's a great editor, and he does it all in a very tight weekend turnaround required for the pod to post every Tuesday morning. Well, it's time for you to hear from Miles himself. Here he is, the man behind the pod, an editor's editor, literally because he's going to edit his own audio this episode. And he's my savior. Take it away, Miles. And then I'll start the cases.
Hey everybody, Miles here. I'm Kevin's producer and editor for Immigration Review. I'm in charge of cleaning up the episode and putting in those circuit split gongs that you hear. Kevin asked me to give myself a little shout out, and after a year of hearing about the BIA, I kind of figured why not. So, it's such a great podcast, and I love being the first listener for each and every episode. Being from Southern California myself, it's good to know that we have so many people fighting the good fight. And keep up the great work, everybody. And that, Kevin, I'll throw it back to you.
First up is Olibris v. Blanche, published by the Fifth Circuit on August 13th, 2026. This is the first of the two Fifth Circuit cases that I just couldn't get to last week, what with the Fifth Circuit issuing 4 in what was already a 14-case week. What the heck, guys? Judge King dissented. I'm actually kind of stoked for this one because it's on a removal statute that we never ever do. I've litigated a related ground years ago, but the client didn't want to take it past the IJ level, which was really a shame. We should have. This is INA Section 237A4AI, which makes removable a non-citizen who has, quote, engaged in the activity to violate or evade any law prohibiting the export from the United States of goods, end quote. Mr. Olibris appears to be a lawful permanent resident from Haiti. From 2019 to 2020, he and an associate purchased 75 firearms in the United States and shipped at least 50 of them to Haiti. No mention whether they were going to the good guys, but also, very not great, and also, that's rarely the case, right? They didn't have the proper licenses to send out these firearms. They got caught, convicted of smuggling goods in violation of 18 U.S.C. Section 554, and a federal judge sentenced Mr. Olibris to a year and a day of incarceration. Seems that in removal proceedings, he applied for asylum, saying that he fears the gangs, and that he was all up in the news for this in Haiti. So I don't know, maybe they were being used against the gangs? I don't know. He later withdrew the asylum claim, though, and applied for only Convention Against Torture deferral. Anywhere but Haiti, essentially. And IJ denied. Quote, the IJ stated that having the international community and an interim government for Haiti restores hopes that order and democratic rule will be restored, end quote. More persuasively, the IJ made other findings, including some fairly detailed adverse credibility findings related to the guns and other things. The BIA affirmed. And so did the Fifth Circuit. Mr. Olibris primarily challenged removability, so here's the statute in full. Section 237A4 provides, quote, security and related grounds. A. In general, any non-citizen who has engaged, is engaged, or at any time after admission engages in 1. Any activity to violate any law of the U.S. relating to espionage or sabotage, or to violate or evade any law prohibiting the export from the U.S. of goods, technology, or sensitive information. 2. Any other criminal activity which endangers public safety or national security. Or 3. Any activity a purpose of which is the opposition to or the control or overthrow of the government of the United States by force, violence, or other unlawful means is deportable, end quote. The argument is that the removability here can only be sustained for someone who is indeed a national security risk or something similar to all the things listed in that statute. The allegation here, though, is simply that it's a violation of an export law. That argument is based on the statutory interpretation canon known as noscitur a sociis, the argument being that the court must interpret the export stuff by considering the words around it, all of which describe national security concerns. Probably butchered that Latin, too. Mr. Olibris argues, for example, though, that notwithstanding the mention of terrorism-type stuff, a broad reading like that applied by the BIA here, quote, could render one removable for illegally exporting a benign item such as a bag of chips, end quote. But the Fifth Circuit believes the text is pretty clear. That is that, exporting without a license will cut it. and so the canon is inapplicable, even if kind of absurd. Do like how the court appears to be kind of applying a categorical approach elements-based analysis to this, though, for what it's worth. But because he's removable and because it rejected the canon argument, that leaves only cat protection for Mr. Olibris, and well, the court didn't see a record worthy of vacature. Too generalized an argument. And while it looks like he may have shown some evidence showing he was known on social media in Haiti for the conviction, he also admitted that he didn't know any gang specifically who wanted to do him harm, much less a person. All of it was too speculative based on a series of suppositions. And it didn't help that he still has family in Haiti, the usual anti-cat stuff for these decisions. Even some of the affidavits submitted in support say things like, quote, "I don't know what will happen, but don't come," end quote. Which may just be like how people talk, but it's being used to support a speculation finding here. On government acquiescence, which is required for cat protection, and while it's a bit unclear to me, it seems to me that the fact that Haiti might not really have a government is hurting the acquiescence argument here, because there's no government that can acquiesce. But maybe I'm overreading. Mr. Olibris also brought a due process challenge, but the Fifth Circuit rejected it. This was about the IJ taking judicial notice of a BBC report to sustain removal. Harmless error, even if a due process violation occurred, and the Fifth Circuit isn't so sure anyway. But there is a dissent. Judge King dissented. Judge King believes the majority, quote, tunnel visions, end quote, its way through a Section 237A4A analysis. Quote, properly read, the statute renders removable only those non-citizens who have engaged or are engaged in espionage, sabotage, or exportations that endanger public safety or national security, end quote. An important read, the dissent, given that I'm not sure there's a precedential decision on this removal statute in any other circuit, and if there is, it's certainly not widespread or widely adopted. Quote, in the majority's view, an unlawful exporter of lays stands on equal footing as a terrorist, a Nazi, and a recruiter of child soldiers. One of these is not like the others, end quote. Indeed. And that is Olibris v. Blanche. Sticking with the Fifth Circuit with Guerra, Quezada et al. The United States. Published by the Fifth Circuit on August 14th, 2026. This case is about derivative citizenship. The appellants here are an uncle and a nephew who claim that their U.S. citizenship flows from the same person, Miss Cruz Rodriguez de Guerra, who is the grandmother and great-grandmother of the appellants respectively. The court affirmed the district court's denial of everything, and there is a lot. Both appellants, and like the entire relevant family tree, is born in Mexico. The claim is that Ms. Cruz Rodriguez de Guerra was not. USCIS granted the nephew a certificate of citizenship in 2021. That's Mr. Guerra Quezada. But apparently, they're in the middle of trying to cancel it. That is USCIS. And both Mr. Guerra Quezada and his uncle, Mr. Guerra Vasquez, have been ordered removed in the past. Mr. Guerra Vasquez was a lawful permanent resident who accepted voluntary departure in 2007, but then entered unlawfully and was convicted of unlawful entry. Mr. Guerra Quezada doesn't have much of a better history, but all of it's irrelevant if they're citizens, right? The pair brought many claims. Administrative Procedures Act, Bivens, FTCA, ADEPA, and I don't even know what all the theories were, or would be. But once citizenship fell for them, the rest didn't have much of a chance, it seems. It looks like the grandma/great-grandmother was indeed a citizen. To make it more confusing, we're dealing with two derivative citizenship statutes because the uncle was born in 1962 and the nephew was born in 1993, and the derivative citizenship law changed in between. But still, as relevant to this case, both statutes would require that the U.S. citizen parent have lived in the U.S. for a certain amount of time. It appears uncontested that the parents of the uncle and nephew here did not do so, even, I guess, assuming that they were citizens. Here's where it gets interesting to me. Quote, the BIA adopted what is now labeled the constructive presence doctrine as a means of satisfying a similar physical presence requirement when determining whether a person has retained their citizenship. The requirement could be satisfied if physical presence was prevented by circumstances beyond the individual's control or by reliance upon erroneous information received from a United States official, end quote. That's matter of Navarrete. published by the BIA in 1967. Apparently no circuit has adopted the doctrine, and several have rejected it, explains the Fifth Circuit. And even still, that would simply be for retaining citizenship, not getting it in the first place, explains the court. And citizenship retention is an archaic concept anyway that only applied to people born after 1952, but that Congress repealed, which is surely why I've never heard of it. The Fifth Circuit isn't going to extend the constructive presence doctrine here, even if it believes it a legitimate thing. Honestly, after that, the court streamlines through the arguments as insufficiently argued or jurisdictionally barred, or as an improper attempt to attack removal proceedings, or multiple of these problems. Seems like the court also suspects AI usage or something else improper is going on, as fake case quotations were provided, albeit from real cases. No action taken against counsel, though, but it came close, that is the court. And the nephew and uncle lost. Judge Ho, in concurrence, is, quote, pleased to concur, end quote, writing to explain why the constructive presence doctrine is wrong, in an opinion that cites to himself and Justice Thomas quite a bit, and in what can only be described, to the untrained eye, as another application by Judge Ho to sit on the U.S. Supreme Court. And that is Guerra, Quezada et al., the United States. Only one from the BIA this week, and I thank you, BIA, I do. It's matter of MMLJ, published by the BIA. This case is about motions to reopen. Mr. MMLJ is from Jordan and was ordered removed after failing to obtain VAWA cancellation of removal in immigration court. The BIA dismissed the appeal of that in 2020. He also had a conviction for criminal impersonation and an arrest warrant for domestic violence himself. After the BIA dismissed the appeal, Mr. MMLJ filed 2 untimely motions to reopen based on a pending I-130 petition filed by his second wife, who was a lawful permanent resident. The second of the 2 motions to reopen also alleged ineffective assistance of counsel against the first attorney. The BIA denied both motions and the Sixth Circuit affirmed. Mr. MMLJ married a third wife, and that wife was a U.S. citizen. The Form I-130 petition filed, and a new motion to reopen was filed after that. The third motion to reopen was denied in October 2025. Currently before the BIA is a fourth motion to reopen based on the same I-130, unsure if it's approved now or not, and another ineffective assistance of counsel allegation against a former attorney. And here's an interesting twist, quote, while the respondent styles his motion as a request for us to exercise our sua sponte authority, in substance he again seeks to equitably toll the statutory time and number limitations on reopening due to ineffective assistance of former counsel, and so we construe it as such, end quote. That's pretty weird, but also none of this is good. The BIA denied the motion. In addition to the 90-day deadline to file a motion to reopen, you can only file one, explains the BIA, unless it's a sua sponte motion to reopen, which is kind of unlimited but very rarely granted, particularly by this BIA. There's a limited VAWA motion to reopen exception too, but it's not applicable here. None of that is particularly new. This, I believe, is, quote, we hold that a non-citizen is permitted to file only one motion to reopen, whether with the immigration court or the BIA, subject to the limited statutory exception for battered spouses, children, and parents, end quote. So you don't get one motion to reopen with the IJ and then one with the BIA. Just one. Choose wisely. Also, not an issue at all in this case, right? No motion to reopen was filed with the IJ. BIA is just kind of taking the opportunity to make the ruling. Mr. MMLJ apparently argued for equitable tolling of the number bar to motions to reopen, something the Sixth Circuit hasn't ruled on, explains the BIA. Unsure if any circuit has, but the Fifth Circuit said definitely not on episode 281 in Garcia-Morin. The BIA has got out in front of the other circuits. Quote, we hold that the INA's number bar on motions to reopen is not subject to equitable tolling, end quote. I will stop to note that none of this likely applies to asylum motions to reopen, though the BIA does have a less than clear footnote on that in this decision. Anyway, the BIA thinks it's weird to equitably toll a numerical limitation, and I must admit I do kind of agree. The BIA believes the statute precludes it, as well as Congress's purpose in the motion to reopen statutes. Lots of this expressly tracking Garcia-Morin. But au contraire, The BIA is well aware that, in fact, the 2nd, 9th, and 7th Circuits, at a minimum, do indeed have case law that holds you can equitably toll a motion to reopen number bar, quote, in some fashion, end quote. That's Zhao v. INS from the 2nd Circuit, Ray v. Gonzalez from the 9th Circuit, and Ramos Braga v. Sessions from the 7th. The BIA doesn't believe the analysis in those cases was thorough, and the BIA believes that maybe the circuits would come out different if, like the 5th Circuit, they had been able to consider the Supreme Court's 2023 decision in Jones v. Hendricks. Still seems like you can equitably toll the number bar in those circuits, though, as the BIA is clear that its new rule here only applies in those circuits that have not yet spoken. Turning to sua sponte reopening, the BIA declined to do it. Quote, there is no exceptional situation on the record before us, end quote, citing to its very recent decision in matter of I&N Dec and all its recent stuff about how you shouldn't reopen just because an I-130 is approved. Also, as written, not the most sympathetic case I've ever read for such things, which may be part of the point. All of that being said, and as I always try to be careful, former appellate immigration judge Andreas Saenz had a more in-depth, detailed criticism of this decision, the procedural history, and the case law that it built upon in a LinkedIn post this week. Check it out. She brings the knowledge. If you're trying to get the full spectrum. And that is matter of MMLJ. You didn't go to law school to enter data. I know I didn't. Yet here you are. H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. Because you deserve a practice that grows without burning you out. Welcome back. I hope you missed me, and I hope you want some crimmigration, because that's what we got. First, Ramdial v. U.S. Attorney General, published by the 11th Circuit on August 21st, 2026. This case is about aggravated felonies. Robbery by sudden snatching, in violation of Florida Statute Section 812.131(1). Surely more culpable than calm, collected, leisurely snatching, which, who knows, maybe isn't an aggravated felony. Mr. Ramdial is from Trinidad and Tobago. Bet it's Trinidad, though. It's always Trinidad. Has anyone ever met anyone from the Tobago portion? Someone email me about this. Mr. Ramdial has been a lawful permanent resident since 2003. Should have naturalized and definitely shouldn't have suddenly snatched in 2019. Worse still, he shouldn't have been convicted of trafficking in hydrocodone, Oxycontin, attempted trafficking in hydrocodone, possession of a Schedule IV controlled substance, alprazolam, and possession of fentanyl. So he's totally removable. But he's still eligible for LPR cancellation removal under I&A Section 248A, so long as the sudden snatching thing isn't an aggravated felony. Why the drug trafficking stuff isn't an aggravated felony, I do not know, but I suspect it has something to do with the categorical approach and some favorable 11th Circuit precedent from the late 2010s and early 2020s. An IJ believed the sudden snatching equated to an I&A Section 11843G theft offense, given that the term of imprisonment was over 1 year, and the BIA agreed. The 11th Circuit has too. Quote, generic theft means the taking of or exercise of control over property without consent whenever there is criminal intent to deprive the owner of the rights and benefits of ownership, even if such deprivation is less than total or permanent, end quote. Now, as an initial matter, the Florida statute is not divisible into separate offenses. Yes, it criminalizes an intent to, quote, permanently or temporarily deprive the victim or the owner of the property, end quote. So that's at least two disjunctive portions. The words or are pretty good tells on that. But those are means, not elements of the offense, explains the court. Quote, Florida standard instruction treats the statute as requiring one intent element, that the defendant committed the taking with intent to permanently or temporarily deprive the victim or owner of the right to the property, end quote. Pretty strong on no divisibility than that. That is the jury instructions. A jury doesn't have to agree unanimously on intent or the victim's identity, so it's not an element that must be established beyond a reasonable doubt. So that's a win for the non-citizen. The least culpable conduct required for conviction just got lower, as it permits temporary deprivations of a non-owner of property, no matter what Mr. Ramdial actually did. That's how the categorical approach works. Still, though, it's a match, explains the court. Because recall, the aggravated felony definition permits a match so long as the state crime requires deprivation less than total or permanent. We'll get to that in a bit, actually. First, the intent and the owner identity stuff. Generic theft does not require as an element intent to deprive only an owner, explains the court. You can intend to deprive a non-owner of the property too. Good argument, though. Looking at the historic definitions of theft and looking to other circuits, the 11th Circuit explains that, quote, generic theft requires a showing only that the defendant intended to take property from a person with a superior possessory interest in the property, end quote. What's that look like in practice? I don't know, you lend a purse to your friend for the night and it's snatched suddenly by another? How about that? That's just me. If Florida, like California, permitted such a conviction to occur where a theft occurred against someone who actually had an inferior interest in the property than the thief, then maybe you'd have an argument, explains the 11th Circuit, distinguishing 9th Circuit precedent. But that's not the case here. Even though you need not steal from the owner in Florida, you still have to suddenly snatch from someone with more of a right to the item than you, the thief, have. Not to get personal. That brings us to argument 2, the temporary deprivation argument. Florida's temporary deprivation requirement here is no different than generic theft, holds the 11th Circuit. It is not the case, explains the court, that a conviction can occur where a defendant temporarily took property from a non-owner who was holding it, then returned it in a de minimis amount of time with no intent to deprive anyone of rights or benefits of ownership. The jury instructions make that clear to the court. This distinguishes the Florida offense in this case from the one in the 11th Circuit's seminal Jagannath v. U.S. Attorney General decision from 2005. Because that statute divisibly permitted conviction for an intent to deprive and an intent to appropriate. Appropriate was where it all turned in Jagannath to the court, but it's not present here. Just an intent to deprive element is what Florida requires for the sudden snatching offense. Whoever's arguing for Mr. Ramdial knows like all the cases. The 11th Circuit doesn't say who it is in their day of decisions, but because of that, the court distinguishes the First Circuit's bomber of a case in DeGraca v. Garland, episode 91, an episode where my notes show that I respected the passing of the artist Meatloaf. The 11th Circuit also distinguished a 2015 Fourth Circuit decision called Castillo, and it's all because those cases were about joyriding and glorified borrowing. No intent to deprive element like that in Florida in this case. And in the case of Castillo, Virginia permitted conviction for consensual takings gone wrong. Those are important distinctions. Nor have Florida courts permitted conviction through de minimis takings. Nor does it matter that the statute doesn't technically use the phrase, quote, without consent, end quote. Kind of a reverse textualism argument, that. And that fails because, quote, Florida law reflects that lack of voluntary consent is inherent in robbery by sudden snatching, end quote. Got in one more snatching. But Mr. Ramdial therefore lost what was clearly a hard-fought case. And that is Ramdial, the U.S. Attorney General. Concluding then with Wong v. Blanche, published by the Second Circuit on August 19th, 2026. This case is about CIMTs and convictions. It regards the precedential BIA decision matter of Wong, episode 101, and then it appeared on episode 203 of the podcast when the Second Circuit first did the case, and it is now returned to the Second Circuit and the podcast post-Supreme Court remand because of Loper-Bright. Mr. Wong lost again. This iteration is primarily about the definition of a conviction at I&A section 11A48A. The CIMT thing is no longer in dispute. What does the Second Circuit believe an immigration conviction is post-Loper-Bright? big question, and it's answered here. To recap a bit, Mr. Wong is from Hong Kong and was admitted to the United States as a lawful permanent resident in 1979. He got an I&A Section 212C waiver in about 1994 for a conspiracy to import heroin conviction. Oh, how different immigration used to be. But he messed up and got convicted of 2 more offenses. First, in 2005, he pled guilty in New Jersey Superior Court to the disorderly persons offense of theft by deception in violation of New Jersey statute annotated Section 2C:20-4, which is punishable by up to 6 months imprisonment and a $1,000 fine. He was ordered to pay $200. Then in 2006, he pled guilty in the New York Supreme Court, which is the lower court, to forgery in the second degree in violation of New York Penal Law Section 170.10, which is punishable by up to 7 years imprisonment and a fine of up to $5,000. For this offense, he was sentenced to 5 years probation in order to pay a $1,000 fine. DHS alleged that those were 2 or more CIMTs not arising out of a single scheme of criminal conduct, and therefore it made him removable. And again, that they are CIMTs is no longer in dispute in this long-pending case. Mr. Wong, however, argues that the New Jersey thing is not an actual conviction. I'm sure that the Second Circuit has answered this question before. In fact, it did in this very case, relying on Chevron deference. None of that is mentioned in this decision, despite that line about stare decisis and low propriety, so that's not nothing. Then again, it was remanded to the Second Circuit for this very purpose. Reviewing the immigration definition at I&A Section 101A 48A, the court starts off by making clear that an immigration conviction includes only, quote, those of a criminal nature. That conclusion follows from the word conviction itself, end quote. So it's got to be a criminal type thing happening in the state to be an immigration conviction. But it does not require a formal adjudication of guilt if guilt is admitted. That's what the IRIRA change was all about, explains the Second Circuit in so many words, because state courts do this all the time and Congress didn't want non-citizens to have a way out. As such, whether a situation where a formal adjudication of guilt is withheld can nevertheless be an immigration conviction turns on, quote, 1, the process of which the finding of guilt is reached, and 2, the criminal punishment that follows at sentencing, end quote. What does prong 1 require? Well, first, guilt beyond a reasonable doubt must be the standard, even if it's through a guilty plea. I think. The decision's slightly unclear to me, so Second Circuit people shoot me a message. The process also must include the right to notice of the accusations, the presumption of innocence, a right to a speedy and public trial, and the right to confront accusers and the witnesses against you. Also must include compulsory process for obtaining witnesses in a defendant's favor, and immunity from second prosecution for the same offense, double jeopardy. So that's not nothing. Those are serious protections. In addition, the Second Circuit explains that a right to a jury trial would be required for offenses that are, quote, serious, end quote, meaning that include a possible imprisonment of over 6 months. A right to counsel, too, must be required if imprisonment or other loss of liberty is possible. A few other things, too, but honestly, guys, if imprisonment and all of that is really at issue, the state is probably going to provide sufficient protections, in my experience anyway. This is about the really low-level stuff. In any event, then, quote, the best reading of the phrase formal judgment of guilt in Section 11848A necessarily entails a proceeding in which these protections are guaranteed, end quote. The second prong of the statute requires that the judgment culminate in a sentence at which a judge imposes or can impose some form of punishment. The court rejected Mr. Wong's counter-proposed definition. It is not the case that, quote, if an offense is not classified as a crime under state law and does not entail the usual disabilities associated with criminal conduct, that the offense cannot result in a conviction under the I&A, end quote. Per the I&A's text, as the court reads it, far less is permitted and will still be a conviction. And it would give too much power to the states and their nuances, when the whole point of IRIRA and immigration law, as the Second Circuit sees it, is uniformity with immigration. Far less is required of the states, again, like what's happening with the New Jersey offense here. To secure a conviction of this nature for theft by deception, the state of New Jersey must prove every element of the offense beyond a reasonable doubt. And all those other rights are present too, as required of not-so-serious offenses at least. As to the sentence, a 6-month term of imprisonment is possible, not to mention a $1,000 fine. And here's a bit of an eye-raising sentence to me at least. Quote, while Mr. Wong was ultimately ordered to pay a fine only, the possibility of incarceration, the paradigmatic affirmative restraint, unquestionably signals that defendants found guilty of that offense must be sentenced, and that they face traditional criminal penalties when they are. End quote. I don't really know what that means, y'all. Is the court saying that just because an incarceration sentence is possible, we have a sufficient immigration conviction? Or is the court saying that because it was possible, the fact that Mr. Wong received only a fine doesn't save him because it is a sufficiently criminal fine? You decide. In conclusion, the Second Circuit expressly did not adopt the BIA's definition of conviction for INA Section 11848A purposes, but also held that Mr. Wong had one nonetheless. 2 actually, and they're CIMTs, so he's removable. And that is Wong v. Blanche. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.